2016, the voters of the United Kingdom gave their instructions to the government by a majority of over 1 million. Since then, it has been both the duty and the policy of the government to implement the result of this people's vote. A vote which the people were promised was a full and final decision which an overwhelming majority of members of Parliament promised to enact. In passing the withdrawal agreement, the government may find it valuable, I believe, to use an instrument of international law called a conditional interpretative declaration to clarify our understanding of the temporary nature of the Northern Ireland backstop. Now, I have been a passionate critic of our relationship with the European Union for decades. There has been a fundamental difference between what the EU has always been and what we were told it was. In the 1970s, we were told it was a common market, a mere economic relationship. Of course, given our geographic proximity, a great deal of economic integration and coordination makes sense. We want to facilitate trade so that our workers and businesses can grow in prosperity together. But the EU was always a project for a political union that the people of this country never fully understood or assented to. It has been clear to me and to many since the Treaty of Maastricht that the EU's trajectory and the desires of the British people were moving in entirely different directions. I questioned Maastricht from inside government in 1993 and was sacked for doing so. I hope a fate doesn't befall the present Minister. And I voted for Brexit in 2016, as did 62% of my constituents in Lincolnshire. I'm sure that my bona fides as a Brexiteer are established. Now, the proposed agreement with the EU consists of 4 legal documents, and I want to use this adjournment debate, which is a quiet moment for reflection, away from the political hurly-burly, to try and go into this in some legal detail. The main agreement deals with citizens' rights, companies being able to fulfil existing contracts, court cases being finalised, and so on. These are sensible and just features of an amicable parting of the ways. Equally, we welcome the 2 protocols providing for continuing cooperation with Cyprus over our sovereign base areas and with Spain considering Gibraltar. It is the protocol on Ireland, known as the Backstop, which causes immense problems. The proposed agreement only deals with the direct questions of how to disentangle ourselves from the European Union's institutions. Now, on the 29th of January, the Commons endorsed the Honourable Member for Altrincham and Sale West's amendment requiring that the backstop be replaced with alternative arrangements. And that is what we are negotiating in Brussels at the moment. The weaknesses of the backstop are manifest. There are legitimate fears that if negotiations for a permanent UK-EU relationship break down, we may find ourselves legally obliged to be stuck in a customs union without end. Indeed, we have read the Attorney General's opinion, which worries many people. So were this to happen, were we to be stuck in a customs union, it would be a complete betrayal of voters and the referendum mandate, not to mention the government's solemn commitments to implement Brexit. Given the current state of play, it looks like there are 4 options at hand. The ideal solution is for the backstop to be withdrawn and the protocol to be withdrawn from the withdrawal agreement. A new protocol could be submitted, committing the UK and the EU to sorting out a trade facilitation agreement using electronic documentation, trusted trader schemes and remote electronic monitoring of cross-border traffic with no hard border or any kind of physical infrastructure. It's not impossible that we could get such an agreement in place by 29th of March, but it is unlikely, unfortunately, given the strong opposition within the EU to changing the agreed text. They simply don't want to unpick the agreement. Indeed, they've made that clear many times.
Madam Deputy Speaker, I thank the honourable gentleman for giving way and for putting forward his viewpoint to the Chamber today. No matter what the issue may be, the unionist population in Northern Ireland are very clear. They don't want to see a backstop. And if there's going to be a removal of that, it has to be a legally binding document that will reinforce and give us the confidence in any process that goes forward. And what we don't want is Northern Ireland to be treated any differently from the rest of the United Kingdom and the mainland. I know the honourable gentleman is saying that. So when we move forward, if we move forward, then the backstop has to be removed, or it has to be time limited, and therefore within this term of Parliament, because therefore we control it in this House in the time that we have available to us.
I entirely agree with that, and I've been working on this issue with international lawyers for some weeks, precisely to try and implement what the DUP want. Partly because this is the way of getting this through Parliament. Secondly, because I actually agree with it. You know, I agree with the DUP. In fact, I agree with the DUP on most things. But I'm just trying to, if the honourable member will be patient, I'm going to try and now outline a legally enforceable way in which we can time limit the backstop. And I think that is terribly important. It's got to be clear-cut, legally enforceable, and above all not subject to any kind of arbitration which is in any way in the hands of the European Union. So I'm trying to get to where the DUP is, and if the honourable member will listen, I hope that I can help him out with a way forward. In fact, I hope I can help out the EU and our government. So I was saying that the unfortunate thing is, and we all know this of course, is that the present deal can't get through Parliament because people don't trust the EU to not spin things out. But the EU say they won't unpick the agreement, so that's why everybody says there is an impasse. Now, I'm not sure that's entirely correct, that there is an impasse, and I think there is a way of proceeding. So I was saying what might happen. I was saying earlier, before that intervention, that we could get an agreement, get rid of it altogether, but that's unlikely given their attitude. So secondly, there is a reasonable possibility that even without any amendments to the current agreement, quote, alternative arrangements could start to operate on the Northern Irish border during the transition period. These would act to supersede the protocol and make it irrelevant before it could be even applied. Indeed, the Prime Minister has said many times he doesn't even want the backstop to come into force. Unfortunately, but understandably, there's not enough trust existing in the Commons to rely on this happening. Thirdly, there is a suggestion of a unilateral exit mechanism, but would be contained within the withdrawal agreement, if you like, which would be renegotiated. But the EU are unlikely to agree to any amendment that allows the UK to exit from the backstop if negotiations are broken down without the EU's consent. That's where we are at the present. Even if such a thing were agreed, the EU could easily prevaricate and deny negotiations are broken down. And that's why I made the point earlier. It's very important that anything is not subject to arbitration, international arbitration. That leaves us with a fourth option, a time limit, clear time limit, very difficult to arbitrate about that. You've reached the time limit or you haven't. That leaves us with a fourth option, a time limit or an end date for the backstop, which can be obtained by a conditional interpretative declaration. And that's what I'm now talking about. And let me try and explain that. And I'm not sure that in these debates that we've had, because of the very short time limits that we've given, I don't think anybody has really had the time to go into the legal background for this. So I think it's quite important that we put it on the record. And as far as I know, my understanding of international law is correct. But of course, we have the Minister here and we have other honourable friends here, and they can put their own viewpoint forward. But at least we can get this debate on the record. Now, let me try and explain. There is a long-established practice of countries making unilateral statements when they ratify a treaty, clarifying how they interpret the wording of a particular aspect of the treaty. The United Kingdom can interpret the wording in the agreement that the backstop is, quote, intended to apply only temporarily, end quote, as meaning it must have an end date. What else is temporary? It has an end date. So it must end after a specified time period. Such a declaration will be subject to the same rules that are applicable to reservations, another term of art in international law, but would not be a reservation itself, as these cannot be applied to bilateral treaties. Even if the other three options are pursued, whether individually, sequentially, or simultaneously, the conditional interpretative declaration would be useful to have on hand already if the first three options cease to be viable, or if the EU won't negotiate on that basis. As international law provides that the rules for declarations follow the rules for reservations, it's useful to consult the United Nations International Law Commission's Guide to Practice on Reservations of Treaties. Guideline 1.2 defines an interpretative declaration as, and I quote, a unilateral statement, however phrased or named, made by a state or an international organisation, whereby that state or that organisation purports to specify or clarify the meaning or scope of a treaty or of certain of its provisions, end quote. A conditional interpretative declaration is a more forceful variant of this instrument of international diplomacy, whereby the United Kingdom would assert that its consent to be bound by the withdrawal agreement is dependent upon the interpretation that the backstop has an end date. Lest one think that interpretative declarations are just a backdoor way of applying a reservation to a bilateral treaty, it should be clarified that their applicability is much less extensive than that of a reservation. Conditional interpretative declarations cannot negate any part of the treaty. That's a vital, important part of what I'm arguing. I'm not trying to negate any part of the withdrawal agreement. These declarations can only constrain the meaning given to part of a treaty. A state's declaration when ratifying a multilateral treaty does not stand in the way of that state remaining a party to the treaty. With a conditional interpretative declaration to a bilateral accord, the outright rejection of the declaration by other parties means a treaty would not come into force. And I'm going to go into this in more detail in a moment. While there's... Yes, of course.
I just wanted at this stage to ask my old friend, just to get on the record, the fact that, of course, this is only a draft withdrawal agreement, and furthermore, it's not signed, we know that. But if signed, it would be a prima facie a treaty. But would the question of a manifest violation of our internal law arise if the consequences of what was in the withdrawal agreement vitiated the integrity, the constitutional integrity of the United Kingdom in relation to Northern Ireland?
Well, that's an interesting political argument, and I'm not sure I'm qualified to give a firm reply. But clearly, there is a lot of concern in the House of Commons, and if the EU is following debates like this, they should be aware of that there is no way in which the House of Commons will ever vote for any agreement that in any way divides up the United Kingdom. And I think we have to make that absolutely clear. If they want to get a deal through, they, in a sense, have to try and, I will give away in a moment, they have to try and listen to creative solutions such as I'm advocating, because I presume that the EU are absolutely insincere in saying that they want a deal. I presume that they are sincere, as Mr Juncker made clear today, that a no deal would be catastrophic, not just for the United Kingdom and the Republic of Ireland, but also for the EU. So I presume they're sincere. They have to understand what my honourable friend has said, and they have to find a way around it. I give way to my honourable friend.
One short point on his comment, simply that he did mention this would be a political consideration. In fact, when I use the word manifest violation, it's actually a term of art, and it arises under Article 46 of the Vienna Convention. But I just thought I'd put that on the record. It's not political, it's legal.
As always, I'm very grateful to my honourable friend, and one of the advantages of these sort of debates is that we can get these sort of legal points across and on the record, and I'm grateful to my honourable friend for making that clear. With a conditional interpretative declaration to a bilateral accord, the outright rejection of the declaration by the other party means the treaty would not come into force, as I've just said before those interventions. While there's every chance the EU might object to a conditional interpretive declaration, this objection might well fall short of outright rejection. Now, I want the House to listen very carefully to that, because I'm trying to find a way forward for Mr. Juncker. If you want, I'm trying to save his face, actually. I'm trying to give him an opportunity to object, but not to indulge in outright rejection. They, the EU, could argue that attempts during negotiations to achieve an end date were rejected. In fact, I'm sure they might start by arguing that. As well, they might argue that an end date would be incompatible with the concept of the free protocols forming an integral part of the agreement, as provided in Withdrawal Agreement Article 182. But perfectly valid counterpoints to these objections exist. We would need to argue that our declaration is compatible with our commitment to use, quote, best endeavours, a very important phrase, to negotiate, quote, alternative arrangements, so that, as provided, the backstop applies, quote, temporarily, if indeed it is ever applied at all. So that's a fundamental point. The fact that the backstop would not necessarily come into force under the terms of the agreement means that, in my view, it is not actually integral to the agreement at all. The termination of the backstop within a reasonable amount of time is fully in accord with the agreement rather than an amendment to it. So the arguments in favour of the applicability of just such a declaration, I think, are very strong. So what about the European Union's likely response to such a move? There are four main possibilities. First, they could accept our interpretative declaration and move ahead with obtaining the consent of the European Parliament to the withdrawal agreement. This might include making a political protest, but accepting the declaration's legality and applicability. This is the ideal response so far as we are concerned. As Guideline 163 states, the interpretation resulting from an interpretative declaration made in respect of a bilateral treaty by a state or an international organisation party to the treaty and accepted by the other parties constitutes an authentic interpretation of that treaty. In other words, we would have obtained a legally binding commitment from the EU to end the backstop. Victory. Second, they could reply with an assertion that the interpretative declaration is in effect an attempt to impose a unilateral reservation and therefore has no legal validity, but at the same time agree to negotiate solely on the question of an end date for the backstop in order to solve the issue head-on. This would mean that they have abandoned their previous insistence that no further negotiations were possible. Again, a way forward. Third, they might reply that the interpretative declaration has no legal validity, but request further negotiations in the hopes of obtaining something of a value in exchange for giving way on an end date for the backstop. Of course.
I commend my right honourable friend for all the work that he's done on this issue and for obtaining this adjournment debate. Unlike me, he is an eminent lawyer, and I'm trying to get my head around some of the complexities of this issue. If the EU, if we invoke this interpretive declaration and the EU object, is it legally challengeable, and if so, in what court?
I think they probably would object politically, but that's not enough. That's the point. If they don't want the interpretative declaration to have effect, to provide an end date for the backstop, there is only one way out of it. They have to refuse to ratify the treaty. A protest, talk of further negotiation, it is not enough. And that, in a sense, is the beauty of this. And that's why we have these vehicles in international law and why they've been used on several occasions in the past. Actually, they've been used by countries such as Argentina and other countries. So there's no point protesting. There's no point getting... I mean, my honourable friend says this is a complicated legal argument. Actually, it's not. It's terribly simple. It's incredibly simple. Under international law, you can say, we interpret this treaty in such a way. We deposit that when we ratify the treaty. It's not a codicil as such. It's not a letter. It's deposited with a treaty. It has all the legal enforceability of a treaty. Now, you, who are ratifying this treaty with us, if you want to escape from the obligations of this, there's only one way out. You have to refuse to ratify. And I would suggest, and I'll make this clear again before I sit down, that the EU, for political reasons, would be unlikely to do so, because it would put all the onus of a no deal on them. I give way to the Honourable Leigh.
I thank the Right Honourable Member for this adjournment debate. I think it's incredibly interesting what he's saying. And I defer absolutely. He knows much more about this issue than I do. But is there a possibility of a situation where the EU, so the UK, would make a conditional interpretive declaration? He has indicated that such a declaration could not negate an aspect of the treaty. Could the EU come to a conclusion that it is not a valid interpretive declaration due to the fact it's trying to do something it cannot do, i.e. negate? So because it is not valid, they can therefore ignore it, and the scenario that he has indicated does not arise.
Well, I think that's a very interesting point. You know, I'm interested in what the Minister says to that, but I think I can give a very firm and strong reply. There is no wriggle room about this. The EU can't say, well, you've made this interpretive declaration, we don't agree with it, we're going to carry on it, but we're going to ignore it, and we're going to impose this backstop on you forever. There's only one way out of it. At the time of... I better be careful what I say, but I think I'm right in saying at the time of the ratification of the treaty, or within a reasonable time limit, they had to refuse to ratify the treaty. Otherwise, they are bound by it. It is part of the treaty. So as far as I'm aware, there is absolutely no... And I know wriggle room, and I know this is terribly important for the DUP, because they want to shut down all the... There is a lack of trust here, and they want to shut down all the possible bits of wriggle room for the EU to get out of this. But as far as I am aware, there is no way out of this. The only way out of it is for them to refuse to ratify the treaty. If the Minister disagrees with that, he can say so in his speech. But I give way to the Honourable Leigh.
Thank the Right Honourable Member for giving away again. Just as a follow-up in relation to that, because in the sphere of international law and disputes, could he clarify for me that in a situation where such a declaration is made and there is a dispute as to the validity of that declaration, so we believe it to be a valid declaration, the EU believes it is not, how is that, following on from the previous intervention, how is that issue then resolved, or how is that arbitrated on? Because you've got two inconsistent positions. They could refuse to react to it because they are ignoring and refusing to accept its validity. So in international law, is there a clear pathway for that in terms of the arbitration?
Well, the Honourable Lady Howe asked how it can be resolved by the EU. They simply refuse to ratify the treaty. There's no deal. End of story. The interpretative declaration falls. The withdrawal agreement falls. We've made clear that we're only going to ratify the treaty on the basis of this interpretative declaration. There is an end date, the backstop. They say, well, we don't agree with that. We're not going to ratify the treaty. That's the end of it. So, I mean, in a way, this is not... you cannot impose this. I think people have misunderstood in thinking that this idea that I've been talking about, we can somehow impose our ideas on the EU. We can't impose our ideas on the EU. But they have to make clear that they're going to refuse to ratify the treaty. I give way to Mark.
I'm most grateful. Would it also be relevant to consider the question of where a reservation by one party to a multilateral treaty is only binding on another party when the second party has not made an objection? This, I think, is a part of the parameters within which my right honourable friend is making his argument. But of course, it's not just a matter of whether or not they refuse it; it's whether or not they actually make an objection. Isn't this something that also ought to be brought into the debate?
Yeah, it should be brought into the debate. There's no way you can ignore this interpretative declaration and argue later in some court of international law that you weren't aware of it or it has no validity or anything. It's pretty clear. This is your time to refuse to accept it. There is, by the way, an argument, which I don't want to get into this level of legal detail. There is an argument about bilateral and multilateral treaties, letters of reservation that I've talked about in the past. And if I've talked about letters of reservation, I apologise, because this would be, I think, be a bilateral treaty with the EU, and therefore interpretive declarations are a more appropriate vehicle than letters of reservation. But I think that's almost becoming too embroiled in the legalisms of this and just legal descriptions. The important thing is the House understands that there is a way forward. So I was saying all the various scenarios about what might happen. Fourth, the EU might reply that the submission of the interpretative declaration in fact invalidates the UK's ratification of the withdrawal agreement and refuse to move on with obtaining the European Parliament's consent, so the agreement can be fully ratified and come into force. Aside from the arguably dodgy legal grounds the EU would be on, because we're only interpreting something which the withdrawal agreement says is the view of both parties. This, as I've said already, but I'd emphasise, this would also have the effect of shifting responsibility for a no-deal Brexit from the UK onto the EU. If we ratify the withdrawal agreement with a conditional interpretative declaration providing for a backstop end date, any ensuing deadlock could be ended in a single stroke by the EU simply deciding to accept the declaration. Again, it must be emphasised that under the terms of the backstop protocol, it is perfectly possible the backstop might never come into force at all. The withdrawal agreement states that its, quote, provisions shall apply unless they are superseded in whole or in part by a subsequent agreement, end quote. Both the UK and the EU are committed to, quote, use their best endeavours, end quote, to conclude an agreement superseding the backstop at the end of 2020, the minimum transition period. The essential purpose of a conditional interpretative declaration, then, is to achieve, before the end of the time limit, a set of trade facilitation procedures, predominantly by extension of existing electronic customs procedures, so applied by the UK to imports from non-EU countries. It is vital that a conditional interpretative declaration brings the backstop to an end without being reliant upon a phrase such as subject to the withdrawal of negotiations. This is a very important point. And I know that some in government have argued that we could get some sort of codicil or declaration around a breakdown in negotiations. But the trouble is all this is subject to arbitration. The EU could argue that they are still using their best endeavours to bring negotiations to an end, they want to go to arbitration, and that's where all the difficulties come in. And that's why I think that the end date point is much the best way of proceeding.
Just on that point, of course, if the arbitration arrangements to which my honourable friend is referring to are by reference to the arrangements of the Joint Committee Arbitration Panel, of course that ultimately, insofar as it engages with European law, will be adjudicated by the European Court of Justice. Of course that takes us back to a point which we couldn't accept.
Well, that's why I'm really trying to find a way forward for the DUP to support the deal, frankly. I'm trying to help the government in all this. And I know one thing the DUP will never accept is anything where there's a whiff of arbitration by the EU, because they don't trust the EU. So we've got to close that down. But I'm quite right, they are opposed to anything which may be subject to arbitration, and I understand their fears. So long as one side is willing to talk, there is a debate as to whether a breakdown negotiations has been reached. So we've got to be careful of that way forward, I think. It's a small legal step which is legally in line with the agreement, but which politically would produce a major change. I think what I'm talking about, putting the UK on a better, more equal footing with the EU in the forthcoming negotiations of our permanent future relationship. Now, the EU, as I've said, does not want a no-deal Brexit, or that's what they've said. If the current deadlock continues and the EU forces a no-deal Brexit upon us, personally, I believe it could be manageable. It might put us back in the driver's seat, and I should think would be able to conclude bilateral agreements to continue on current terms until long-term agreements are worked out. Given that we'd continue our membership in the World Trade Organization, their set of trade rules would apply in this situation, which means, in a sense, it isn't really no deal at all. It certainly isn't crashing out. But I know that businesses are desperately seeking reassurance, and I know that there are political problems, which I don't need to go into at the moment, about no deal outcomes. And I know that many farmers and agribusinesses in my own constituency in Lincolnshire want to know the trading context of the coming years in order to plan and adapt accordingly. So while the withdrawal agreement is far from perfect, that's the nature of compromise, it does deliver on some essentials. And we need to make good on our promise to the British people to deliver Brexit on time. In conclusion, I say to the Minister, I hope all this is helpful. It's designed to try and achieve a compromise. It won't please everybody, but if we're not prepared to compromise, if us Brexiteers and if our Remainer friends try to get everything we want or they want, one side or another may be in for a very big disappointment. And I don't want to take any risk with Brexit. I'm sorry, that is my view. I think this would be catastrophic for the government. We have to deliver Brexit on the 29th of March, or within 2 or 3 weeks thereafter to get through the proper legislation. We have to get through a deal which Parliament can accept. And I hope that what I've been talking about this afternoon may be one small step in making that possible. Thank you.
Sir William Cash.
Thank you very much, Madam Deputy Speaker. I just wanted to make a few comments because I really do pay respect to my honourable friend for coming forward with this ingenious and no doubt very carefully analysed proposal. But I do have to say that because of the importance of this question, I wouldn't want there to be any smoke and mirrors which would come out of it or come out of the mouth of the Attorney-General when he does make his statement. And I believe he will be doing so in due course. Not quite sure about the timing of it at the moment, but my honourable friend may recall that, Madam Deputy Speaker may recall that I raised this question in the exchanges a couple of days ago when I said that my European Scrutiny Committee is looking very carefully at this matter, and furthermore, the question of the validity of the Attorney-General's opinion or statement or whatever form it takes when he makes it is something which ought to be done by at least Monday of next week to give everybody an opportunity to assess the nature of it, including some of the points that have been made in this debate by my honourable friend, in order to be sure that when he does make such a statement, it actually stands up. What we don't want is a smoke and mirrors operation. We don't want anything which is actually going to sound terribly important, but in practice turns out to be effectively something of less significance than it might sound when it's first uttered. I mean, we had this situation in the Iraq War when I was Shadow Attorney General, and the opinion of the Attorney General, which I sought through questions that I put because the Attorney General was in the House of Lords, and I raised various questions about him giving an opinion, and eventually he came forward with a truncated opinion, but subsequently I think it would be fair to say he, despite the fact that it silenced a lot of critics during the course of the debate itself, actually that was because they were blinded by science and they didn't really know quite what he was talking about because it all came out so quickly. Now, this is what we must avoid. This is why I'm insisting, as Chairman of the European Scrutiny Committee, that we get plenty of proper examination and time for that examination of the wording that the Attorney-General, who's currently in Brussels discussing this very question, comes up with. So I feel that that is an important warning, as it were, to put it down as a marker. We don't want to be bounced. I mean, with Chequers, the Cabinet was bounced. There's no doubt about that. They've been planning this for about 18 months. We don't want this to turn out to be another bouncing operation. And if it is, and if what an honourable friend was to put forward after consideration, which I know has already gone to the Attorney-General, this thinking is built into the discussions that he's having out there in Brussels as we speak, then it's incredibly important that the House isn't bounced by it. It's difficult enough, and my honourable friend and I are here on our own pretty much in this debate, with the exception of honourable friend member for Cleethorpes and honourable lady opposite. But the reality is that when the House is going to be packed when a statement of this kind is made, if it is made, And when it is, the most important thing is it's been properly assessed and analysed before the statement is made, anticipating any problems that might arise. I mean, for example, I just mentioned this. The Attorney General, as it's been stated, and my honourable friend will know the origin of this, in his advice to the Prime Minister, concluded that in the situation of the backstop being activated, quote, the protocol would endure indefinitely until a superseding agreement took its place. There is not even any mechanism for a superseding there is not even any mechanism for the EU and the UK to agree on termination of the backstop if negotiations were to break down. The Attorney General advice was restricted to the text of the protocol. He was not asked to consider whether the impact of the protocol could be constrained by a UK unilateral statement in the form of a conditional interpretative declaration.
I thank the right honourable member for giving way. Unfortunately, I will have to leave. I will miss my flight. Otherwise, I may do so anyway at this time. But this is incredibly interesting. But I just want to concur absolutely with what he has said, because I think what is important in all of this is not a discussion about what is legally possible, or even what is legally probable. I think for many, many of us, including in the DUP, but I think many people across this chamber, what we want is what is legally certain, or insofar as that is possible to achieve legal certainty. So I think there's lots of interesting ideas, but that is absolutely critical. We must all be sure of the legal certainty insofar that that is possible before we can agree the way forward.
I'm deeply grateful to the Honourable Lady, because that is exactly my line of argument. And it's not just a question of wanting to be obstructive for its own sake. That is perfectly well understood, I hope. But it is incredibly important that the House isn't bounced or confronted with smoke and mirrors, or by something that they haven't completely understood, and they all go off and they vote, and then afterwards somebody says, oh, well, actually, that doesn't stack up. And I know my honourable friend would entirely agree with what I'm saying on that, and I know the Minister would as well, I said, looking at nodding his head, which I'm grateful for, because it really is important, because we are talking here not just about something like a free trade agreement in Canada, the CETA arrangements, with which my committee has also been looking very closely, but actually it is something of profound and fundamental constitutional significance. And I am deeply concerned that the EU has taken an intransigent position. We know what Martin Selmayr is reputed to have said, that the price that the United Kingdom will have to pay for the way in which it's carried on, I'm paraphrasing, but that it would be the price would be Northern Ireland. We know that there are powerful forces in the Republic who would like to see United Ireland, and there are those who also believe that this whole backstop argument has been engineered in a way that would lead to the possibility of a border poll and ultimately to a United Ireland. There are some very clever lawyers at work in all this, and it's our job, I think, in this House, with such resources as we have available, to try to penetrate that fog and to make it crystal clear that it is not a solution which could possibly be put forward, which would have the effect of undermining the constitutional status of Northern Ireland within the United Kingdom. So I don't think I need to say very much more. It's really in the nature of a very profound concern. I'm sure it will be understood in Downing Street and in the Attorney General's own mind, and therefore I don't think I need to add any more other than to say I'm extremely grateful to my honourable friend for the way in which I've understood what he's seeking to achieve. The danger would be if we ended up by moving down a route which looked plausibly good, but actually turned out to be not merely a bear trap, but a disaster.
Minister.
Thank you very much, Madam Deputy Speaker. And I have to say, this is, in my 9 years in the House, this has been a very extensive adjournment debate, and I'm very grateful for it. I'd like to congratulate my right honourable friend, the member for Gainsborough, for securing this debate. The issue that we're dealing with here, the backstop, reflects our commitment to avoiding, as you know, Madam Deputy Speaker, and as my right honourable friend knows, a hard border on the island of Ireland. Now, I know through history that my right honourable friend does have experience in trade matters. He was an Under-Secretary, like I am today. He was an Under-Secretary in the Department of Trade and Industry. And he does speak also as a lawyer, so he has considerable expertise, I think, in many of these issues. And the other thing I wanted to bring to the attention of the House was that he has indeed engaged with the Prime Minister, my right honourable friend, the Prime Minister, on precisely this issue of the conditional interpretative declaration. I'll say a few words about that later in my speech. I'm grateful to him, as is the government, for sharing his thoughts on conditional interpretative declarations. This was not a mechanism that was known to me. I've read his letter with consideration. I've done my own research. And with my team in the department, we have our own views as to the strength, plausibility, if you like, Madam Deputy Speaker, of this mechanism. Now, the House will remember that members of this very House, sent a clear signal to the government and to this country that a deal could be supported, but this support was conditional. In the only positive expression of its desired means to achieve our exit from the EU, this House asserted that obtaining legally binding changes to the backstop would be what is required in order to secure support for the withdrawal agreement. And the government, I have to stress this, the government is entirely convinced that this is where we need to address, this is the question that we need to address, and this is where we need to get some measure of progress. My right honourable friend has highlighted one possible means by which a change to the backstop could be secured, and we are still committed to having legally binding changes that deal with the concerns expressed across the House on the backstop. Now, in terms of the substance of the changes we are seeking, as of today, we are still looking at various means. We haven't necessarily gone down one route, nor have we gone down another. I notice that the entire opposition bench is empty, but as a courtesy to the House, I will still address the empty benches.
Just as a matter of fact, I sincerely hope that the Minister will be addressing the chair and not any benches in particular. And just as a tip, if he does address the chair, he'll find that the microphone picks up his voice better because it's adjusted in such a way. Minister.
I thank you, Madam Deputy Speaker, very much for those tips. I was just making a rather flippant observation about the... I don't think I've ever seen entirely empty opposition benches. But to resume my remarks, clearly the government has set out, and the Prime Minister has mentioned, three possible routes, three ways in which the backstop can be addressed. And members in the House will know those three options, but I just feel, for the sake of the record, that we need to recapitulate those. The first, obviously, was whether the backstop could be replaced with alternative arrangements. And those alternative arrangements, Madam Deputy Speaker, are expressed exactly in the political declaration. They are arrangements which would avoid a hard border between Northern Ireland and Ireland. And this process has been led very constructively by my right honourable friend, the Secretary of State, and he has been engaging with MPs across the House, indeed, on this particular issue. My right honourable friend, the Secretary of State, has also discussed alternative arrangements with the ongoing Alternative Arrangements Working Group in Brussels, with Monsieur Barnier. The Commission has changed its language, I think, in the last few weeks, and it is beginning to engage seriously with the proposals that we have suggested. Although the Commission has expressed some concern about the viability of alternative arrangements, I would suggest that they are more flexible and open to these alternative arrangements than they have been hitherto. quite happy to give way.
Would the Minister also accept that, as he's made it clear, the only basis on which this entire analysis and investigation and possible wording could be effective in the government's mind would be if it was legally binding? What is manifestly obvious, of course, and we know that, do we not, is that the political declaration which he's referring to at the moment is not legally binding, and therefore to conduct the alternative arrangements on the basis of a political declaration which is not legally binding just simply doesn't wash.
My right honourable friend, with his customary acuity, is stressing and reinforcing what I've already said and what the government has said. We are seeking, and I quote, I say once again, legally binding changes to the backstop. That's what we are seeking. The government has also looked at this issue of a time limit to the existing backstop. And this is where my right honourable friend, the member for Gainsborough, where his suggestion plays its part. My right honourable friend's suggestion is that conditional interpretative declarations could be employed as a mechanism for interpreting what exactly is meant by temporary in relation to the backstop, and defining this in such a way that means, or rather results in the fact that the UK would not be bound indefinitely to the backstop. It is, I think, an elegant solution at first reading. But an issue has arisen with respect to exactly how binding such a conditional interpretative declaration would be. My guidance has been that, and a key aspect that we have to consider, Madam Deputy Speaker, is that the need for any changes, or rather any changes, would in fact still have to be jointly agreed by both parties. Because within the terms of, and my right honourable friend actually for Gainsborough pointed the way in this, within the terms of the withdrawal agreement, which I have studied carefully, the Northern Ireland Protocol, which is about 185 pages, clearly sets out in fairly clear terms, some might even say stark terms, the roles of the Joint Committee and the fact that any end of the backstop would have to be mutually agreed. Now, it is unclear to me, and it is unclear to a number of people who've looked at this from the point of view, in the interests of the government, whether such a conditional interpretative declaration would actually allow the United Kingdom unilaterally to impose an end date for the protocol. And my right honourable friend, in his very comprehensive and excellent speech, also suggested that such an interpretative declaration, Madam Deputy Speaker, could not contravene the withdrawal agreement itself.
Minister, he's most kind. But the other point just to throw into this equation, surely, is also the fact that the question of whether or not the European Court of Justice would be, at the end of this process, able to adjudicate on the outcome, because it would be manifestly in the minds of the EU that this was a matter which engaged European law.
Well, as my right honourable friend will know, the status of the backstop will be subject, I suppose, to the scrutiny of the Joint Committee. And he is suggesting that the Joint Committee ultimately will be somehow in the jurisdiction of the European Court. This is not actually, as far as...
Order. I'm sorry to startle the Minister. It being 5 o'clock, we have to move the adjournment again.
I beg to move that this House do now adjourn.
The question is that this House do now adjourn. Minister.
Thank you, Madam Deputy Speaker. So a very important point has been raised by my right honourable friend in respect to the role of the Joint Committee and its supervision, if you like, of the backstop should we enter into the backstop. This is precisely what we are negotiating at the moment, the relationship of, and our ability to get a codicil or some form of change in the withdrawal agreement. This is precisely what's being debated. So we have to await the outcome of those negotiations. What I'm willing to stress, however, in the course of this debate, is that it is not entirely clear that despite my right honourable friend's excellent efforts to reach a solution in this regard, it is not entirely clear that the conditional interpretative declaration that he has suggested would in fact have the effect that he seeks in allowing the United Kingdom unilaterally to put an end to the backstop. This, I have to say, is an open question and doesn't actually provide the mere fact that it's debatable, does not actually provide the certainty and the finality that we would seek in making the changes that he would like to see to the backstop. Let me conclude once again by thanking my right honourable friend again for initiating and securing this debate. This is my first adjournment debate, and I'm delighted that I should have been so ably accompanied by two outstanding members of this House who have really graced our presence and have contributed to debates, particularly on this question of Europe, over many years. I, like them, was a Brexiteer. I'd like to reinforce the remarks that my right honourable friend for Gainsborough made about the need really to get a finality on this. I think it's a remarkable testament to the right honourable member for Stone and the right honourable member for Gainsborough that in the course of their parliamentary careers they should have seen us leave the EU. I don't think this is something which maybe they believe they would have seen this day, but I think this is something that should be noted. It's an extraordinary thing that we are now in the end phase, if you like, of our membership of the EU, and I think that's something that shouldn't be forgotten. The government obviously continues to look at ideas as we seek to achieve changes to the backstop. My right honourable friend for Gainsborough has provided one possible vehicle for doing so. I only alert him to some of the circumstantial, and circumspect views that we have about this particular mechanism. But it's an ongoing debate, and I'd like to thank him very sincerely for his contribution. He always provides useful detail and good sense in these debates, and I look forward to engaging with him further as we continue this ongoing discussion about the nature of Brexit and the future of our country after we leave the EU.
Thank you. The question is that this House do now adjourn. As many as that opinion, say aye.
Aye.
The ayes have it. The ayes have it. Order. Order.